Hello everybody, thank you for joining me. I'm JD Hoovener, managing partner here at Bold Patents Law Firm. We're going to be talking about the 10 tips of how to come and prepare for a meeting with your patent attorney. And what I want to do is go through them one step at a time. I'm sure that you're going to be able to gain some knowledge and insight from what I've got to share here today. I've sat down with hundreds of inventors and business owners that are looking to get their patents protected, and I can help you in this episode with how to come prepared to get the most out of that meeting. Like, for example, did you know that coming to a meeting with a history, you know, the backlog of the who invented what, when, way back then when you conceived it, that's critical to being able to make a good decision on how to protect your invention today. So without further ado, let's jump into it. All right, so tip number 1, do your own diligence first. Yep, you've got to show up prepared, and that means you taking the time to do some research up front. Know what process you're getting into. Don't just schedule an hour out of your day, your hard-earned money and your time and effort to block that time out without first doing a little bit of research. And so that starts with looking into the patent process, but more importantly, looking into your invention. You should do some initial research on Google. It's a fantastic research tool to begin to sort of scratch the surface on how to appreciate whether your invention is really different. Know that the keystone for getting a patent is you've got to be able to prove to the examiner that you and your invention is one of a kind and the first of its kind in the world. All right, so those kind of research you should do on your own before you get into the meeting. It's going to allow you to be able to come in with a bit of a knowledge about what to expect, the timelines, the process, what credentials you're going to be looking for, and more importantly, you're going to know that you've done your own homework to convince yourself that what you have and what you're bringing forward is indeed novel and new. All right, step number 2. You want to prepare the invention for discussion. This is kind of a no-brainer, right? But you've got to be able to write down in written words, if you're nervous and worried about skipping over certain parts of your invention, then write it down, right? Get a Word doc, type it up, or handwrite the points about your invention that you want to talk about with the patent attorney. When you get into a room, face-to-face meeting, emotions kind of rise up, and you might forget about something. So to make sure you don't, write it down. Of course, what's better than words? Pictures or sketches and drawings. So please bring them in. And if you've got them in hand size and they're reasonably portable, bring in your prototype. This is going to be the best way to discuss your invention in the 30 minutes or an hour, however long you have with your patent attorney. They need to know what the invention's about to be able to make their own opinions about whether it's eligible and certainly patentable. They need to sort of get their arms around it and get a good understanding as far as what the industry and the applications are for your invention. So come prepared, bring a written description, sketches, drawings, or even photos of your invention. They all help for having that great discussion. All right, so tip number 3 is going to be preparing the history. And I alluded to this at the beginning of the video, and yeah, that sounds kind of boring. And no, I'm not talking about bringing up the history of the materials, way back when. I'm talking about when you invented this, right? Was it just you, or were there any other co-inventors? And how long ago did you first conceive it? This is the kind of history we need to be talking about. Bringing in the employer-employee relationship that you may have at the time. Also discussing ownership. So if you were inventing this while you were on the job, is it actually going to belong to someone you worked for? And more important than some of these inventorship ownership questions is the disclosure, right? So have you ever told anyone about your invention? It's time to come clean. You've got to tell your patent attorney and prepare to help them understand when you made the disclosure and what was talked about. On top of that, you got to make sure you note if you used any non-disclosure agreements. And if that's the case, make sure to bring those agreements with you if you've got a copy of it. So putting a timeline together of what's happened in the past on this invention. Maybe you were spinning your wheels about this years ago. Start with that, right? When did you first conceive of the invention? It's going to help the attorney in their thought process about what issues may come up that need to be addressed before you, for example, file an application. Step number 4, make sure that you consult with a patent attorney, not a patent agent. And it starts with a key understanding that a patent attorney has gone to law school. The importance of having an attorney speak with you is you're going to be able to understand the full spectrum of helping you acquire rights and being able to enforce them way down the road. The attorney is going to have the knowledge, the legal knowledge of what it takes to enforce and litigate a patent in federal court or the Patent Trial and Appeal Board. Having an invention with claims without really any foresight is something that patent agents are able to provide. And it's a service and sometimes has great applications. But for most inventors and business owners that want to make sure that their rights are going to be able to be valid and enforceable in court of law is really where you want to start. On top of that, some of the opinions, the legal opinions that you should be using to be able to make the decision on whether you're going to file or not can only come from a patent attorney. When you're going to look to make a big investment on something you've worked hard on, like your invention, you want to make sure you're working with a patent attorney. Step 5, know who you're going to be talking with. Sure, it's a law firm, and that's comprised of lots of different attorneys and staff and paralegals, but your consultation is with one individual, right? He or she, whoever that is, you need to do research on them. Pull them up on Facebook, LinkedIn, Google, and don't forget to take a look at their uspto.gov registration. Confirm that they're actually patent attorneys registered on the Patent Office website. So don't miss that. I mean, this is some of the stuff you've got to do because you're putting in your own time and effort in talking with them. And in many cases, you're putting up your own money to pay for the consultation fee. This is kind of part of that diligence, but I wanted to call it out specifically. Who it is you're talking with. It will be important to make the conversation flow. And so on top of the technical stuff that you're going to be bringing, right, in steps 3 and 4 we learned, you got to also make sure you consider their background and see if it's a good match. It's often helpful to have the attorney's industrial or scientific background align with where your invention is going. You may also be curious to find out that some of the attorneys, patent attorneys, have business backgrounds as well. They're going to be able to give you some insight as to how you're going to be able to make money and seek a real return on investment that you're looking for. Step 6. This is about understanding where you want to go and where you want to end up. At the very beginning stages, you're thinking about getting the protection, right? Getting your invention exclusive, owned by you and your entity. When you do this, you want to make sure that you're thinking about what the end result's going to be. Is it to be a business, right? Are you going to start and grow the next Facebook, the next Amazon? And is this technology going to be the core? And that's going to mean you're going to have to hire employees, form a business entity, perhaps take on funding, all these big questions that add legal liability and, of course, opportunity in the marketplace. So having those goals of whether you're going to grow a business or if you're going to license and sell your invention, right? Those are two very different paths, and it's helpful to let your patent attorney know that so that they can either refer you to good professionals to help you with the banking and the business formation and the attorney legal work that'll need to happen when you form your employment agreements and contracts. But if it's something much more simple and you're looking to simply license and monetize and sell your patent rights to another company to then take it off in the market, that's another much more simple process, but we need to know that so we don't make those referrals, or that we can focus your efforts just on the monetization side. Okay, step 7, send the materials to your patent attorney in advance. Again, this is a way to be able to capitalize and leverage that half hour. You can send over as many photos, sketches, written descriptions, drafts that you've put together as the inventor, search results. These are all very powerful things you can send in email confidentially to your patent attorney before you sit down and talk with them. This is going to be a way for them to sort of feel obligated in a way, even if they haven't volunteered. You're going to say, hey, look, if you get a chance, just pull these up before our consult, and it's going to make that meeting even more rich. You're going to be able to ask very substantive questions, and they're going to have a little bit of background about what your invention is and helping you make the most out of your 30 minutes with them. Step 8, bring everything to the table. You've got to do it, or you got to trust your patent attorney with your entire invention. All attorneys, whether they're licensed in any state in the country, they all swear an oath to confidentiality. As one of these major high notes, the privilege that we have as attorneys is the ability for you, the client, to be able to confide in us. That is a core essence of why we went to law school, why we went through the arduous process of passing a state bar. Patent attorneys have even done that up one more. We've taken a patent bar, and in that bar passage and certification process, we also obligate ourselves to keeping all information for inventors confidential as well. So you've got sort of a double layer of protection there. If you only give us half of the invention, or half of what's on your mind, you're only going to get half of a legal opinion, right? So give it your all, and then that way you can expect a full, complete answer to help you make a good decision on how to move forward next. When you come to the meeting, tip number 9, be present. Be fully present. Don't have your phone sitting on the table with all the alerts flipping back and forth. Turn it off. Don't be thinking about what's coming up in your lunchtime meeting after the consult. Try to leave everything that you had over the weekend, all the interesting aspects with friends and family. Really be fully present. Try to just block everything else out so you can truly focus on the meeting. And this goes really for any professional meeting, but specifically one for an invention discussion that's going to be highly technical, and it's going to talk about an area of law that you're likely unfamiliar with. You've got to be completely laser focused and be able to bring those questions that you've prepared in advance so we can take good notes and understand how it's going to move forward. So again, don't be driving. Don't be in a loud, noisy area if it's a video conference. Be in a quiet room with a setting and you're sitting down, comfortable, prepared, and engaged with your attorney. Tip number 10, you are the inventor. Sure, you've got the options of hiring a number of different patent firms, but don't forget that you too are being interviewed to see if you're a good fit for the firm. Your invention may be potentially conflicting with other clients at the firm, but moreover, the law firm wants to make sure that you are committed and that this is a project that they see being a long-term success for both parties. It really is a joint effort when you talk about working with an inventor and a patent attorney. They've got to be able to mesh, and they've got to make sure that both people, sort of on a technical but also on a personal level, are able to be on the same page and make sure that we're aligned. So when you come, bring your A game. Act like you're being interviewed because you do want this patent attorney to be on your team. All right, well, there they are. There are the 10 tips, everybody. So if you did like that, please give us a thumbs up on social media. We try every day to try to make these sort of videos, the kinds of videos that you watch. And so we need your input. I'm curious to see what your thoughts are. Please give me some comments and feedback. We want to be able to put some topics on here that are relevant to you, the listener, the inventor, the entrepreneur. It's been my pleasure to be here with you to go through the 10 tips on how to prepare to be with your patent attorney. I'm your host, JD Hoovener of the Bold Today Show. Go big, go bold.
Go big, go bold.